In this part 31 of our lecture series, we will continue with our discussion regarding taking cognizance of an offense, with which you have started discussing right from section 190 up to section 199 of the Criminal Procedure Code. And during the course of our last lecture, we have learned that there are some statutory restrictions with respect to the right of the court to take cognizance of an offence are laid down right from section 195 up to section 199 of the Criminal Procedure Code. So this is the time for me to remind you that whenever we deal or refer to sections, it is necessary for you to know the offences, and hence there must be simultaneously you must study the offences so that it becomes possible for you to understand the provisions with which we are dealing. Though we are dealing with the provisions of the Criminal Procedure Code, as I have told you in the past, in the absence of understanding the importance of the sections with which we are dealing as far as Indian Penal Code is concerned, it may not be possible for you to understand the Criminal Procedure Code. So now, if you read section 195, it says prosecution for contempt of lawful authority for public servants, for offences against public justice, and for offences relating to documents given in evidence. And which is, the question of enumeration. This section says, no court shall take cognizance of any offence punishable under section 172 up to 188, both inclusive of the Indian Penal Code, or of any abatement or of attempt to commit such offence, or of any criminal conspiracy to commit such offence, except on the complaint in writing of the public servant concerned, or of some other public servant to whom he is administratively subordinate. Nextly it says, of any offence punishable under any one of the following sections of the Indian Penal Code, namely section 193 to 196, both inclusive, section 199, section 200, section 205 to 211, both inclusive, and section 228, when such offence is alleged to have been committed in or relation to any proceedings in any court, or of any offence described in section 463, or punishable under section 471, section 475, or section 476 of the said code, when such offence is alleged to have been committed in respect of document produced or given in evidence in a proceedings in any court, or any criminal conspiracy to commit or attempt to commit, or the abatement of any offence specified in subclause 1 of the same section, except on the complaint in writing of that court or by such officer of the court as the court may authorize in writing in this behalf, or of some other court to which that court is subordinate. And further part says, where such a complaint has been made by a public servant under subclause A of subsection 1, any authority to which he is administratively subordinate may order the withdrawal of the complaint and send a copy of such order to the court, and upon its receipt by the court no further proceedings shall be taken on the complaint, provided that no such withdrawal shall be ordered if the trial in the court of the first instance has been concluded. Now, as this is made very clear as far as section 195 is concerned, that when the court shall take cognizance of an offence, some other details are mentioned as far as further part of this section is concerned. And then if you read section 195A, it says procedure for witnesses in case of threatening, etc. And it says a witness or any other person may file a complaint in relation to an offence under section 195A of the Indian Penal Code. Whereas the next section, as I have told you, which is again a question of enumeration, section 196 says prosecution for offences against the state and for criminal conspiracy to commit such offence. It says no court shall take cognizance of any offence punishable under chapter 6 or under section 153A, section 295A, or subsection 1 of section 505 of the Indian Penal Code, or a criminal conspiracy to commit such offence, or any such abatement as is described in section 108A of the Indian Penal Code, except with the previous sanction of the central government or the state government. It also says no court shall take cognizance of any offence punishable under section 153B or subsection 2 of subsection 3 of section 505 of the Indian Penal Code, or a criminal conspiracy to commit such offence except with the previous sanction of the central government or of the state government or the district magistrate. It also says no court shall take cognizance of the offences of any of the criminal conspiracy punishable under section 120B of the Indian Penal Code, other than a criminal conspiracy to commit an offence punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upwards, unless the state government or the district magistrate has consented in writing to the initiation of the proceedings. Provided, it says, that where the criminal conspiracy is one to which the provisions of section 195 apply, no such consent shall be necessary. Rest of the details are worked out as far as the rest of the part of this section is concerned, namely section 196. With this now, if you read section 197, which says prosecution of judges and public servants, and it says when any person who is or was a judge or magistrate or a public servant not removable from his office save by or with the sanction of the government is accused of any offence alleged to have been committed by him while acting or purporting to act in the discharge of his official duty, no court shall take cognizance of such offence except with the previous sanction. In a case of a person who is employed, or as the case may be, was at the time of commission of the alleged offence employed in connection with the affairs of the Union of the central government, or in case of a person who is employed, or as the case may be, what at the time of the commission of the alleged offence employed in connection with the affairs of the state or the state government, provided that where the alleged offence was committed by a person referred to in clause B during the period while a proclamation issued under subclause 1 of article 356 of the Constitution was in force in the state, will apply as it for expression state government occurring therein, the expression central government were substituted. No court shall take cognizance of any offence alleged to have been committed by any member of the armed forces of the Union while acting or purporting to act in the discharge of his official duty except with the previous sanction of the central government. The state government may by notification direct that the provisions of subsection 2 shall apply to such class or category of members of the armed forces charged with the maintenance of public order as may be specified therein, wherever they may be serving, and thereupon the provisions of that subsection shall apply as if for the expression central government occurring therein, the expression state government were substituted. And rest of the details are worked out as far as the rest of the part of this section, namely section 197, is concerned. With this now, prosecution for offences against marriage, namely when the offence is committed as it is enumerated right from section 493 up to section 498 of the Indian Penal Code, when the court shall take cognizance is dealt, and when the court shall take cognizance of it is dealt as per section 198 is concerned. It says, no court shall take cognizance of an offence punishable under chapter 20 of the Indian Penal Code except upon a complaint made by some person aggrieved by the offence. So there must be complaint on the part of the aggrieved person to set criminal law into motion as far as offences against marriage are concerned. But the proviso says, provided that where such person is under the age of 18 years, or is an idiot or a lunatic, or is from sickness or infirmity unable to make a complaint, or is a woman who according to the local customs and manners ought not to be compelled to appear in public, some other person may, with the leave of the court, make a complaint on his or her behalf. Where such person is the husband and is serving in any one of the armed forces of the Union under conditions which are certified by his commanding officer as precluding him from obtaining leave of absence to enable him to make a complaint in person, some other person authorized by the husband in accordance with the provisions of subsection 4 may make a complaint on his behalf. Where the person aggrieved by an offence punishable under section 494 or section 495 of the Indian Penal Code is the wife, complaint may be made on her behalf by her father, mother, brother, sister, son or daughter, or by her father's or mother's brother or sister, or with the leave of the court by any other person related to her by blood, marriage or adoption. Now for the purposes of subsection 1, no person other than husband of the woman shall be deemed to be aggrieved by any offence punishable under section 497 or section 498 of the Indian Penal Code, provided that in the absence of husband, such person who had care of the woman on his behalf at the time of such offence was committed may, with the leave of the court, may make a complaint on his behalf. When, in a case falling under subclause A, small a, of the proviso to subsection 1, the complaint is sought to be made on behalf of the person under the age of 18 years or of a lunatic, or by a person who has not been appointed or declared by a competent authority to be a guardian of the person of the minor or lunatic, and the court is satisfied that there is a guardian so appointed or declared, the court shall, before granting the application for leave, cause notice to be given to such guardian and give him a reasonable opportunity of being heard. The authorization referred to in clause B of the proviso to subsection 1 shall be in writing, shall be signed or otherwise attested by the husband, shall contain a statement to the effect that he has been informed of the allegations made, which the complainant is to be founded, on which the complaint is to be founded, shall be countersigned by his commanding officer, and shall be accompanied by a certificate signed by that officer to the effect that the leave of the absence for the purpose of making a complaint in person cannot for the time being be granted to the husband. Any document purporting to be such an authorization and accompanying with the provisions of subsection 4, and any document purporting to be certificate required by that subsection shall, unless the contrary is proved, be presumed to be genuine and shall be received in evidence. No court shall take cognizance of an offence under section 376 of the Indian Penal Code where such offence consists of sexual intercourse by a man with his own wife, the wife being under 18 years of age, if more than 1 year has elapsed from the date of the commission of the offence. And then the provisions of these sections apply also to the abatement of or attempt to commit an offence as they apply to these offences. Section 498A, prosecution of offences under section 498A of the Indian Penal Code. And it says, no court shall take cognizance of an offence punishable under section 498A of the Indian Penal Code except upon a police report of facts which constitute such offence, or upon a complaint made by the person aggrieved by the offence, or by her father, mother, brother, sister, or by her father's or mother's brother or sister, or with the leave of the court by any other person related to her by blood, marriage, or adoption. And then section 199 says, in case of prosecution for defamation, no court shall take cognizance of an offence punishable under chapter 21 of the Indian Penal Code except upon a complaint made by some person aggrieved by the offence, provided that where such person is under the age of 18 years, or is an idiot or a lunatic, or is from sickness or infirmity unable to make a complaint, or is a woman who according to the local customs and the manner ought not to be compelled to appear in public, some other person may, with the leave of the court, make a complaint on his or her behalf. Now subclause 2 says, notwithstanding anything contained in this code, when any offence falling under chapter 21 of the Indian Penal Code is alleged to have been committed against a person who, at the time of such commission, is the President of India, the Vice President of India, the Governor of a state, the Administrator of a Union Territory, or a Minister of the Union or the state or the Union Territory, or other public servant employed in connection with the affairs of the Union or the state in respect of his conduct in the discharge of his public functions, a court of session may take cognizance of such offence without the case being committed to it upon a complaint in writing made by a public prosecutor. So this is the cognizance of an offence may be taken by the court of session directly as per subclause 2 of section 199, which is an exception that cognizance of an offence is always taken by the court of judicial magistrate, to which this is an exception. Now subclause 3 of section 199 says, every complaint referred to in subsection 2 shall set forth the facts which constitute the offence alleged, the nature of such offence, and such other particulars as are reasonably sufficient to give notice to the accused of the offence alleged to have been committed by him. No complaint under subsection 2 shall be made by the public prosecutor except with the previous sanction of the state government in case of a person who is or has been the governor of that state or minister of that government, of state government, in case of any other public servant employed in connection with the affairs of the state, of the central government in any other case. No court of session shall take cognizance of an offence under subsection 2 unless the complaint is made within 6 months from the date on which the offence is alleged to have been committed. Now last part of the section says, nothing in this section shall affect the right of the person against whom the offence is alleged to have been committed to make a complaint in respect of that offence before a magistrate having jurisdiction or the power of such magistrate to take cognizance of the offence upon such complaint. With this now, as it was told by me in the past, along with this chapter, this is also the time for us to understand that though we say that anybody can set criminal law into motion, and the magistrate may have power to take cognizance of an offence, magistrate shall not take cognizance of an offence after expiry of the period of limitation, and this is exactly dealt by limitation for taking cognizance of certain offences, and it starts right from section 467 up to section 473 of the Criminal Procedure Code. Now, if you read section 467, it says, for the purposes of this chapter, unless the context otherwise required, period of limitation means the period specified in section 468 for taking cognizance of an offence. And section 468 says, bar to taking cognizance after lapse of the period of limitation. And it says, except as otherwise provided elsewhere in this code, no court shall take cognizance of an offence of the category specified in subsection 2 after the expiry of the period of limitation. And subclause 2 says, the period of limitation shall be 6 months if the offence is punishable with fine only. B. 1 year if the offence is punishable with imprisonment for a term not exceeding 1 year. And subclause 3 says 3 years if the offence is punishable with imprisonment for a term exceeding 1 year but does not exceed 3 years. And it also says, for the purposes of this section, the period of limitation in relation to offences which may be tried together shall be determined with reference to the offence which is punishable with the more severe punishment, or as the case may be, the most severe punishment. Now, with this when we start, this is the period of limitation which is laid down as far as section 468 is concerned. But when this period, may be period of 6 months, may be period of 1 year, or may be period of 3 years, the commencement of the period of limitation, and section 469 makes it very clear, the period of limitation in relation to the offender shall commence A. on the date of the offence. So it shall commence on the date of the offence, or where the commission of the offence was not known to the person aggrieved by the offence or to any police officer, the first day on which such offence comes to the knowledge of such person or to any police officer, whichever is earlier. Or where it is not known by whom the offence was committed, the first day on which the identity of the offender is known to the person aggrieved by the offence or to the police officer making investigation into the offence, whichever is earlier. Now, subclause 2 makes it very clear, in computing the same period, the day from which such period is to be computed shall be excluded. So this is as far as the commencement of the period of limitation, which is made very clear as far as section 469 is concerned. Now there is certain period which can be excluded at the time of computing the period of limitation, which is made very clear as far as section 470 is concerned. This says, in computing the period of limitation, the time during which any person has been prosecuting with due diligence another prosecution, whether in a court of first instance or in the court of appeal or revision against the offender, shall be excluded, provided that no such exclusion shall be made unless the prosecution relates to the same facts and is prosecuted in good faith in a court which from defect of jurisdiction or other cause of like nature is unable to entertain it. Secondly, it says, where the institution of the prosecution in respect of an offence has been stayed by an injunction or order, then in computing the period of limitation, the period of continuance of the injunction or order, the day on which it was issued or made and the day on which it was withdrawn shall be excluded. Thirdly, where a notice or prosecution for an offence has been given, or where under any law for the timing in force the previous consent or the sanction of the government or of any other authority is required for the institution of any prosecution for an offence, then In computing the period of limitation, the period of such notice, or as the case may be, the time required for obtaining such consent or sanction shall be excluded. Now, explanation makes it very clear. In computing the time required for obtaining the consent or sanction of the government or any other authority, the date on which the application was made for obtaining the consent or sanction and the date or receipt of the order of the government or other authority shall both be excluded. Fourthly, it said, in computing the period of limitation, the time during which the offender has been absent from India or from any territory outside India which is under the administration of the central government or has avoided arrest by absconding or concealing himself shall be excluded. Now, 471 makes it clear that where the period of limitation expires on the day when the court is closed, the court may take cognizance on the day on which the court reopens. And the explanation says, a court shall be deemed to be closed on any day within the meaning of this section if during its normal working hours it remains closed on that day. With respect to continuing offence, it says, 472 says, in case of any continuing offence, a fresh period of limitation shall begin to run at every moment of the time during which the offence continues. And extension of period of limitation in certain cases is made very clear as far as section 473 of the Indian Criminal Procedure Code is concerned, which says, notwithstanding anything contained in the foregoing provisions of this chapter, any court may take cognizance of an offence after the expiry of the period of limitation. So, court may take cognizance of an offence after expiry of the period of limitation if it is satisfied on the facts and in the circumstances of the case that the delay has been properly explained or that it is necessary to do in the interest of the justice. So, this is a discretionary power which vests in a court of law to condone the delay and to take cognizance even after expiry of the period of limitation as per the conditions which are laid down as far as section 473 of the Criminal Procedure Code is concerned. With this now, there are certain offences for which this period of limitation is not made applicable, and that is made very clear as far as the economic offences in applicability of Limitation Act of 1974 accordingly. With this now, this is the time for us to proceed further to understand as to when there is a complaint which is made to the magistrate by as referred to subclause 1 of section 155, namely somebody goes to the magistrate and complains to the magistrate. What is the procedure that is required to be followed by the magistrate is laid down right from section 200 up to section 203, which deals with dismissal of a complaint, with which we intend to do during course of our lectures. We will also start discussing the importance of right from section 204 up to section 210 of the Criminal Procedure Code, dealing with the further steps or how the process or when the process can be issued by the court of law, and rest of the details with which we will continue our discussion as far as next part of our series of lectures is concerned.